Hello everyone, I'm Anu, an engineer and a law graduate, and welcome to my channel where law meets logic and learning becomes easy. If you're a law student preparing for your semester exams, or simply someone passionate about understanding how laws shape our world, you're in the right place. In this series, I'll be covering important questions from each subject, semester-wise, all explained in simple, structured, and student-friendly language. Today, we're diving into one of the most important subjects, family law, Hindu law. We'll explore key concepts, important legislation like the Hindu Marriage Act, succession laws, adoption, maintenance, and more. So make sure to subscribe, grab your notes, and let's decode the law, one topic at a time. What we will cover are 1. Who is a Hindu and to whom does Hindu law apply? What are the sources of Hindu law? Ancient, original, modern, and secondary. 2. What are the main schools of Hindu law? Explain the Mitakshara and Dayabhaga schools and their differences. 3. What is the Hindu Marriage Act 1955? Explain why Hindu marriage is considered a sacrament and not a contract. 4. What are the essential conditions for a valid Hindu marriage? Distinguish between void and voidable marriages. 5. What are the grounds for divorce and judicial separation under Hindu law? 6. What is adoption under Hindu law? Explain the requirements and legal effects under the Hindu Adoption and Maintenance Act, 1956. 7. Define maintenance under Hindu law. Discuss its nature and extent under Old and Modern Hindu law. 8. What is the Hindu Succession Act, 1956? Explain its scope, main features, and the general rules of succession for male and female Hindus dying intestate. 9. What is the Hindu Minority and Guardianship Act, 1956? Who is a minor? And what are the types and powers of guardians? 10. Discuss the rights, liabilities, and responsibilities of guardians under Hindu law regarding the property and welfare of minors. Question 1. Who is a Hindu and to whom does Hindu law apply? What are the various sources of Hindu law? Introduction. Hindu law is one of the most ancient systems of personal law in the world, governing family matters such as marriage, divorce, adoption, succession, and maintenance among Hindus. In India, personal laws are based on religion, and Hindu law specifically applies to Hindus, Jains, Sikhs, and Buddhists. This legal framework is derived from both ancient religious texts and modern legislative enactments. This answer will explore who is a Hindu, who Hindu law applies to, the various sources of Hindu law, ancient, modern, and secondary, relevant case laws and examples. 1. Who is a Hindu? There is no specific definition of the term Hindu in the Constitution of India or the Hindu personal laws. However, the term has been interpreted by the judiciary over the years. According to Section 2 of the Hindu Marriage Act, 1955, a person is considered a Hindu if they are a follower of Hinduism, Buddhism, Jainism, or Sikhism, a person who is born of Hindu parents and raised in a Hindu environment, a person who is not a Muslim, Christian, Parsi, or Jew, and is not governed by any other religious law. Explanation under Section 2 of Hindu Marriage Act, 1955, states that the Act applies to any person who is a Hindu by religion in any of its forms or developments, including a Virashaiva, a Lingayat, or a follower of the Brahmo, Prarthana, or Arya Samaj, any person who is a Buddhist, Jain, or Sikh by religion, any other person domiciled in the territory of India who is not a Muslim, Christian, Parsi, or Jew by religion. Example, if a child is born to Hindu parents but later adopts another religion, such as Islam, they cease to be governed by Hindu law unless they reconvert. Case law, Perumal vs. Ponuswamy, 1970. In this case, the court held that a person born as a Hindu remains a Hindu unless they convert to another religion through a clear and unambiguous act. 2. To whom does Hindu law apply? Hindu law applies to the following categories: Hindus by birth, legitimate or illegitimate children of Hindu parents. If one parent is Hindu and the child is raised as a Hindu, Hindus by religion, followers of Hinduism, Buddhism, Jainism, Sikhism, Hindus by conversion or reconversion, persons who convert or reconvert to Hinduism, presumption of Hinduism. A person living in a Hindu society and behaving like a Hindu is presumed to be governed by Hindu law. Case law, Ram Prasad versus State of UP, 1970. It was held that a person who is not a Christian, Muslim, Parsi, or Jew will be presumed to be governed by Hindu law unless proved otherwise. Trend sources of Hindu law. The sources of Hindu law are classified into two categories. A. Ancient sources. These are traditional sources derived from religious and moral texts and have a foundational role in shaping Hindu jurisprudence. They include Shruti, that which is heard, refers to the four Vedas, Rig Veda, Samaveda, Yajurveda, and Atharva Veda, considered to be divine revelations heard by sages. They lay down principles of dharma, duty, and righteousness, which form the core of Hindu law. While not directly dealing with specific legal rules, they provide moral and ethical guidance. Smriti, that which is remembered, authored texts remembered and passed down by sages. These include rules and guidelines derived from Shrutis, but interpreted in the context of practical life. Major Smritis. Manusmriti focuses on duties and roles of individuals in society. Yajnavalkya Smriti, more progressive and systematic. Narada Smriti, more oriented toward legal and judicial practices. These Smritis provided a code of conduct for individuals and societies in ancient times. Commentaries and digests, Nibandhas. Over time, different regions followed different interpretations of the Smritis. Commentaries are explanations of Smritis, while digests are compilations from multiple sources. Notable works: Mitakshara by Vijnaneshwara, commentary on Yajnavalkya Smriti, followed in most parts of India. Dayabhaga by Jimutavahana, followed mainly in Bengal and Assam, emphasizes inheritance by merit rather than birth. Custom, Achar. Custom is an important and independent source of law. Types of custom: local custom, prevailing in a particular region. Class custom, followed by a caste or community. Family custom, practiced within a specific family. A valid custom must be ancient, certain, reasonable, and not against statutory law or morality. Case law, Collector of Madura versus Muthu Ramalinga Sethupathi, 1868. Privy Council recognized custom as a valid source of law and stated that where a custom is proved, it prevails over written law. B. Modern sources. These sources are legislative and judicial developments that have modified or clarified traditional Hindu law, legislation, statutory law. With the codification of Hindu law post-independence, several acts were enacted. Hindu Marriage Act 1955 governs marriage, divorce, legitimacy, etc. Hindu Succession Act 1956 governs inheritance and succession. Hindu Minority and Guardianship Act 1956 covers guardianship laws. Hindu Adoptions and Maintenance Act 1956 regulates adoption and maintenance. These laws ensure gender justice, uniformity, and adaptability in the modern era. Judicial decisions. Courts interpret the provisions of ancient and modern Hindu laws. The principles laid down by the Supreme Court and High Courts are binding and serve as precedents. They fill gaps where legislation is silent or ambiguous. Justice, equity, and good conscience. In the absence of any legal or customary rule, courts rely on fair, moral, and equitable decisions. This principle allows flexibility and a human approach in delivering justice. Case law, Gurunath vs. Kamlabai, 1954. Court relied on equity principles when no clear legal provision was available, ensuring justice was served. See secondary sources, Western influence. These sources reflect the influence of British colonial administration and modern legal thought. Doctrine of precedent. Under Article 141 of the Constitution, Supreme Court decisions are binding on all lower courts. Ensures consistency and predictability in law. Commentaries of modern jurists. Scholars like Mullah, Main, and Derrett have written extensively on Hindu law. Their commentaries are often cited by courts and students alike. English law principles. During British rule, when Hindu law was silent, English legal principles were applied, especially in matters of evidence, contracts, and procedure. This influence led to the evolution of Hindu law in areas like guardianship and inheritance. Conclusion. Hindu law is a rich and ancient legal system that continues to evolve through legislative reforms and judicial interpretation. The definition of a Hindu is broad and inclusive, extending its applicability to a wide range of people based on birth, religion, or conduct. The sources of Hindu law reflect both its traditional religious roots and modern statutory framework. Ancient texts like Shruti and Smriti laid the ethical foundations, while modern laws and judicial decisions ensure relevance in today's society. Understanding these sources helps appreciate the dynamic nature of Hindu personal law in India. Question 2. What are the main schools of Hindu law? What are the differences between Mitakshara and Dayabhaga schools? Introduction. Hindu law, as derived from ancient texts and traditions, has been interpreted and applied differently across various regions in India. These interpretations led to the formation of different schools of Hindu law. The two most prominent among them are the Mitakshara and the Dayabhaga schools. These schools not only reflect regional variations, but also present distinct approaches to concepts like inheritance, property rights, and the joint family system. This answer explores the main schools of Hindu law, the key differences between Mitakshara and Dayabhaga, relevant case laws, and practical examples. 1. Main schools of Hindu law. There are broadly two major schools of Hindu law, the Mitakshara and the Dayabhaga. The Mitakshara school is derived from the commentary called Mitakshara, written by Vijnaneshwara on the Yajnavalkya Smriti. This school is followed throughout India, except in Bengal and Assam. Within the Mitakshara school, there are further sub-schools based on regional variations. These include the Benares school in northern India, the Mithila school in Bihar and parts of Nepal, the Bombay school in Maharashtra and Gujarat, the Dravida or Madras school in southern India, and the Punjab school in the Punjab region. The Dayabhaga school is based on the treatise Dayabhaga, authored by Jimutavahana. This school is mainly followed in the regions of Bengal and Assam. The Dayabhaga school is considered more liberal and progressive in certain aspects, particularly regarding inheritance rights of women and individual ownership of property. 2. Differences between Mitakshara and Dayabhaga. One of the most significant differences between these two schools lies in the concept of right to property. Under the Mitakshara school, the right to ancestral property arises by birth. This means that as soon as a male child is born into a Hindu joint family, he becomes a co-parcener and gains a right in the ancestral property. This results in the formation of a Hindu undivided family, Chuf, where the property is jointly owned by the co-parceners. In contrast, under the Dayabhaga school, the right to ancestral property does not arise by birth. A son acquires rights in the father's property only after the father's death. Thus, there is no concept of automatic formation of a co-parcenary at birth. The father enjoys full ownership and control over the property during his lifetime and can dispose of it as he wishes. Another important distinction is in the principle of inheritance. The Mitakshara school follows the doctrine of survivorship. When one co-parcener dies, his interest automatically passes on to the surviving co-parceners. This system does not allow for absolute ownership of the share by any one member unless a partition is effected. On the other hand, the Dayabhaga school follows the principle of succession. When the father dies, his property is inherited by his heirs according to prescribed rules. There is no automatic survivorship among family members. In terms of women's rights, the Mitakshara school traditionally did not recognize women as co-parceners. They could not demand a share in the joint family property, nor could they be a part of the co-parcenary. However, the Dayabhaga school is more progressive in this regard. It recognizes the rights of widows and other female heirs to inherit property, and they can become absolute owners of the inherited share. With respect to alienation of property, under the Mitakshara system, no single co-parcener can sell, gift, or mortgage joint family property without the consent of other co-parceners. Since the property is held jointly, decisions regarding it must be made collectively. In contrast, under Dayabhaga, since the property is individually owned after succession, each heir can alienate his or her share without the need for consent. Religious obligations also play a role in the two schools. In Mitakshara, the concept of inheritance is often linked with spiritual duties, such as performing the pindan, funeral offerings, and other rites. In Dayabhaga, the focus is more on secular inheritance rather than religious duties. Mitakshara school of Hindu law, origin and authority. The Mitakshara school derives its name from the famous legal commentary, Mitakshara, written by Vijnaneshwara, a renowned jurist in the 11th century. His work is a commentary on the Yajnavalkya Smriti, one of the ancient texts on dharma and law. The Mitakshara school is the most widespread school of Hindu law and is followed in most parts of India, including Uttar Pradesh, Bihar, Madhya Pradesh, Rajasthan, Maharashtra, Karnataka, and Tamil Nadu. Key characteristics: right by birth. One of the fundamental principles of the Mitakshara school is that a son acquires a right in the ancestral property by birth. This concept is known as the doctrine of coparcenary by birth. As soon as a male child is born, he becomes a coparcener in the family and gains an interest in the joint family property. Coparcenary system. Under the Mitakshara system, a coparcenary is a narrower body within the larger Hindu undivided family, HUF. Only male members, originally, up to 4 generations can be coparceners: the father, his son, grandson, and great-grandson. After the Hindu Succession Amendment Act 2005, daughters are also considered coparceners with equal rights. Doctrine of survivorship. When one of the coparceners dies, his interest passes automatically to the surviving coparceners rather than through inheritance laws. This doctrine emphasizes the continuity of the joint family. Restrictions on alienation of property. Since the property is considered joint and collective, a single coparcener cannot sell, mortgage, or gift joint family property without the consent of other coparceners, except in cases of legal necessity or benefit to the estate. Limited role of females. Traditionally, female members were not coparceners, although they had limited maintenance and inheritance rights. However, after 2005, daughters have been granted the same status as sons. Partition. Any coparcener has the right to demand partition of the property. Once partitioned, each coparcener becomes the individual owner of their share. Example: suppose Ram has 2 sons, Mohan and Sohan. In the Mitakshara school, as soon as Mohan and Sohan are born, they acquire a birthright in the ancestral property held by Ram. Even Ram cannot gift the entire property without their consent. Important case law. Gurunath vs. Kamalabai, 1954. The court emphasized the coparcenary nature of property and limited powers of alienation. Vinita Sharma v. Rakesh Sharma, 2020. The Supreme Court declared that daughters are also coparceners by birth, and their rights are not dependent on the father's status at the time of the amendment. Dayabhaga School of Hindu Law. Origin and authority. The Dayabhaga school is based on the treatise Dayabhaga, written by Jimutavahana, a jurist from Bengal. This school is primarily followed in West Bengal and Assam. Unlike Mitakshara, which is a commentary, Dayabhaga is an independent digest and reflects a more liberal interpretation of the ancient texts. Key characteristics. No right by birth. In contrast to Mitakshara, the Dayabhaga school states that sons do not acquire any right in ancestral property by birth. They get their share only after the death of the father. This is called the doctrine of inheritance or succession. No coparcenary by birth. There is no concept of coparcenary at birth. Therefore, the father has absolute rights over his property during his lifetime. He can sell, gift, or will his property without consulting his sons. No doctrine of survivorship. Inheritance happens only through succession after death. Hence, the property of the deceased is distributed among heirs as per rules of succession and not automatically passed to surviving coparceners. Female rights. Dayabhaga is more progressive in relation to women's rights. It allows female heirs, such as widows, to inherit property and even become full owners of it. It gives widows a right to inherit their husband's share, which was not the case under traditional Mitakshara law. Alienation of property. Since there is no coparcenary during the father's lifetime, he has full rights over the property. He can alienate property freely without consent from children or other family members. Spiritual benefit principle. In Dayabhaga, inheritance is based not only on blood relations, but also on the capacity to offer pindan, funeral offerings. This spiritual consideration determines the order of inheritance. Formation of coparcenary. A coparcenary may form only after the father's death when the sons inherit the property together. Before that, there is no joint ownership or coparcenary. Example: suppose Raj has a house inherited from his father. Under the Dayabhaga system, Raj retains full ownership of the house. His sons have no right in the property during Raj's lifetime. Only after Raj's death will the property be divided among his heirs. Important case law. Suraj Bunsi Koer v. Sheo Prasad, 1880. The Privy Council clarified that sons under Dayabhaga do not acquire rights by birth, and inheritance begins only after the father's death. Bajnath v. Tej Bali Singh, 1907, reinforced the principle that in Dayabhaga law, property devolves through succession, not survivorship. 3. Key legal concepts explained with examples. To better understand the differences, consider the concept of coparcenary rights. Suppose a father has two sons. Under the Mitakshara system, as soon as the sons are born, they acquire equal rights in the ancestral property along with the father. This means that any property inherited by the father from his ancestors becomes joint family property, and the sons have a right in it from birth. In contrast, under the Dayabhaga system, the father retains full ownership of the property during his lifetime. Only upon his death do the sons inherit the property. Thus, there is no coparcenary or joint ownership during the father's lifetime. Another example is the right to dispose of property. In the Mitakshara system, if a father wishes to sell ancestral property, he must obtain consent from his sons and other coparceners. In the Dayabhaga system, since there is no coparcenary, the father can freely dispose of his property. A relevant case law is Suraj Bunsikwer vs. Sheo Prasad, 1880. The Privy Council held that under the Dayabhaga law, a son does not acquire rights in the father's property by birth, but only after the father's death. 4. Impact of the Hindu Succession Amendment Act 2005. The Hindu Succession Amendment Act 2005 brought a revolutionary change, especially in the Mitakshara system. Before this amendment, daughters were not considered coparceners under the Mitakshara law. However, the amendment granted equal rights to daughters as sons, making them coparceners by birth. This means that daughters now have the same rights as sons in joint family property. They can demand partition, sell their share, and are liable for debts to the extent of their share. The amendment also abolished the doctrine of survivorship, making inheritance based on succession even in Mitakshara families. A landmark case in this context is Vinita Sharma vs. Rakesh Sharma, 2020. The Supreme Court held that daughters have coparcenary rights by birth, irrespective of whether the father was alive at the time of the 2005 amendment. This judgment ensured gender equality in inheritance laws under Hindu personal law. Conclusion: the Mitakshara and Dayabhaga schools of Hindu law offer different interpretations of property and inheritance rights. Mitakshara emphasizes joint family ownership and rights by birth, while Dayabhaga supports individual ownership and inheritance after death. Though these differences were significant historically, legislative reforms and judicial interpretations have now harmonized many of the principles, especially in favor of gender equality and individual rights. Understanding these distinctions is essential for a comprehensive grasp of Hindu family law. Do like and subscribe for more videos, and don't forget to check out the other videos on this channel as well. In the next part 2, we will continue with the remaining important topics. What is the Hindu Marriage Act 1955? Explain why Hindu marriage is considered a sacrament and not a contract. What are the essential conditions for a valid Hindu marriage? Distinguish between void and voidable marriages. What are the grounds for divorce and judicial separation under Hindu law? Please like, share, and subscribe. Thank you for watching.